Jefferson County Court at Law number 2 is now in session on today's date of August 30th, 2022. We're having a arraignment docket. Mr. Burbank, you have a matter that you'd like to bring before the court?
Sure, Your Honor. One is, I believe there's one in custody at this time, but he had a pending felony.
Yes, that's Darius Jones, 3 cases, cause number 326-196, cause number 327, cause number 327-016.
He's, as you know, Judge, vacationing in the county jail. The felony has been reset for a couple of weeks. It is a jail time offer. So I'd ask that it be reset back to then, and then.
So you want to reset his misdemeanor cases with his felony
To the
case?
felony, and we'll take care of it. If they're not going to be dismissed, then we'll take care of it all at the same time.
Okay. Okay,
Yes, they were on Zoom this morning.
okay.
And then there's a Mr. Banks, a Donovan Banks, Your Honor.
Hold on a minute.
He's here. He is here.
Banks,
Yeah. When I went over to,
hold on a minute.
oh, I'm sorry.
What pages? Once you get Mr. Banks in the court? Yeah, he is, okay.
You said you were dismissing that case, right? Anybody?
He's on the last page.
Matter of fact, let me give you a stamp of my signature.
On all the judgments.
That was your brother, wasn't it, that passed? I'm sorry. So I read it after the fact. And sorry.
Okay, and Mr. Banks, please stand on next. This is cause number 332-822, case to style the state of Texas versus Donovan Jovan Banks. Mr. Banks, is that your full name? How you doing, Mr. Banks? I'm doing fine. Thanks for asking, Mr. Banks. You're here represented by your attorney.
Nobody.
Oh, yeah, I see that. Yeah, I don't see nothing on here as a representative. Okay.
If I may, Your Honor.
I see you represent him on the felony case.
That's correct, Your Honor. When Mr. Banks came in to hire me, we talked about the misdemeanor. And because we are such an efficient law firm, I hope they're looking at us in YouTube. They failed to file a motion of parents of counsel for Mr. Banks in the misdemeanor case.
Okay, this is what we're gonna do. Give him that, we're gonna give him that form, judge's explanation of rights to defend us without attorney, where he fills out and says that he has hired an attorney, put your name in it, put his initials and
Oh,
signature.
but
on
he
it.
has. I'm here to represent.
I know, but I'm just saying, do we have have you been here before? Okay, yeah, he needs to sign that paper, fill that paperwork out, and then once that's filled out, they're going to give him, you need a call number?
Yes, Your Honor.
It's 332-822-822.
332-22.
And once he fills that paperwork out, please stand over there by our court coordinator. She's gonna reset his case. And when his case is reset, you'll be free to go and you have a blessed day. And then Mr. Burbank, the case will be reset and yeah, with the felony, but then you still have to have your office send in a letter of representation.
30th.
Okay.
You're asking a lot of things.
Oh.
Your Honor, thank you very much.
You
Can I
are.
be excused to-
You welcome. Yeah,
Can I be excused to that?
yes. Y'all have a blessed day.
Thank you. Thank
Okay.
you, Your Honor.
All right, you welcome. He's gonna sign, Banks is gonna sign.
Right here, right now.
Yeah, and give it,
Well, no. Okay, go ahead and sign it now.
okay, let's see. Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. Today, you have been asked to come to this court for what is called an arraignment. An arraignment is an opportunity to tell you what you've been charged with, what your rights are, and what options you have concerning your case. The case that you have in this court is a misdemeanor case. Criminal cases are divided into felonies or misdemeanor, but your case is a misdemeanor case. If you had a felony case, your felony case are normally referred to as your more serious type offenses. And the reason why that is because the range of punishment is much greater. The case that you have is a misdemeanor case, and the misdemeanor cases are normally referred to as petty offenses. Does not mean that they're not serious. It just means that they are not as serious as the felony case. That just simply means that the range of punishment or the punishment is much lower than your felony case. Now, if you have a felony case, it will fall into one of 5 categories. It can be a capital murder, a first-degree felony, second-degree felony, third-degree felony, or state jail felony. If you had a state jail felony, and if you were convicted of a state jail felony, the range of punishment is 6 months to 2 years in the state jail. If you had a third-degree felony, the range of punishment, if convicted, is minimum 2 years to a maximum of 10 years, plus a fine of $10,000. Now, it's a fine of $10,000 also in the state jail felony case. If you had a second-degree felony, the range of punishment is minimum 2 years to maximum of 20 years in the state penitentiary, fine up to $10,000. If you had a first-degree felony, the range of punishment is minimum 5 to a maximum of 99 years to life in the state penitentiary, a fine up to $10,000. Now, the highest felony is a capital murder. And if you're convicted of a capital murder, you could be given either life or death as punishment. Now, the offense that you have here is a misdemeanor offense, and it will fall into one of 3 categories for misdemeanors. It could be a Class A misdemeanor, a Class B misdemeanor, or a Class C misdemeanor. If it's a Class C misdemeanor, normally Class C misdemeanors are handled in the Justice Court, which is the JP court, or in the City Court, which is the municipal court. And the range of punishment for those offenses are fine only. You only could get a fine. You cannot get into jail time for a Class C misdemeanor. The next highest misdemeanor is a Class B misdemeanor. The range of punishment for a Class B misdemeanor is minimum 0 days to a maximum of 180 days in the county jail if you're convicted, a fine from $0 to $2,000, or you could be given both such fine and confinement. For a Class A misdemeanor, which is the highest misdemeanor, the range of punishment is minimum 0 days to 365 days, which is a year in the county jail. Or you could be given a fine from $0 to $4,000, or you could be given both such fine and confinement. Now, as a defendant in a criminal case, you have rights. One of the rights that we're going to go over is your right to have an attorney. Now, that paperwork that you have in your hand, it talks about your right to have an attorney. And basically, the paperwork informs you that with your right to have an attorney, you have 3 options. Number 1, you have, you have a right to hire your attorney. That's one option. Number 2, the other option is if you cannot afford to hire an attorney, you may ask the court or request the court to appoint you a court-appointed attorney. That's the second option. Or the third option is you may waive your right to an attorney and represent yourself. So those are the 3 options that you have regarding your right to have an attorney. Now, if you want to hire an attorney, or if you want to hire an attorney, then your case will be reset to give you time to do so. Now, if you want to have an attorney appointed to represent you, then you have to fill out what is called a financial questionnaire so that the proper person can determine whether or not you qualify or you meet the eligibility requirements for the appointment of a court-appointed attorney. And then the third option is you have a right to waive your right to have an attorney. And what I mean by waiving your right to have an attorney, that means that you're giving up your right to have an attorney and you're desiring to represent yourself. Now, you may not speak to the prosecutor. The prosecutor is the assistant district attorney who is representing the state of Texas in the case against you. Now, you may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Okay, ladies and gentlemen, let me do this here. Let me go back over this document, which is, the document is judge's explanation of rights to defendants without an attorney. And it states that as a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Or number three, you may represent yourself. If you want an attorney to represent you and you have enough money to hire an attorney, your case will be reset to give you time to do so. If you want an attorney and do not have the money to hire an attorney, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor. The prosecutor is the assistant district attorney who's handling the case. You cannot speak to that person about your case unless you sign a written waiver. What a written waiver is, you're waiving your right to have an attorney. A waiver is that you're giving up your right to have an attorney and you say that you want to represent yourself. So until you do that, you can't talk to the prosecutor. Now be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. At the bottom of that document, it states defendant's choice, marking issues next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you'll put your initials, you'll place your initials on the first line to the left. If your choice, well, if you have already hired an attorney, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for court-appointed counsel, That is, you want to apply for a court-appointed attorney. Then you'll place your initials on the third line to the left. If you have already been appointed a court-appointed attorney in your case, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to, or if your choice is, I want to waive my right to an attorney, which means I want to give up my right to an attorney and represent myself, then you'll put your initials on the third line, on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, you will sign your name on the line that's titled defendant. And you will place today's date, which is August 30th of 2022 on the line that's titled date. Now, for those of you who will be waiving your right or giving up your right to have an attorney and representing yourself, you have to read and sign the next document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And it states, I have been advised of the nature of the charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 30th day of August of 2022 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that is your choice, then you will sign your name on the line that is titled defendant, and you will place today's date, August 30th of 2022, on the line that is titled date. Now, as a defendant in a criminal case, you also have other rights. One other right that you have is the right to have a trial by jury. In that area over there where those young people are sitting, we call that the jury box. 6 citizens from Jefferson County will be selected on your case as the jury, and they will listen to all of the evidence. And then after listening to all of the evidence and deliberating, they will decide whether or not you're guilty or not guilty of your charge. You also have a right to waive your right to have a trial by jury, which means you have a right to give up your right to have a trial by jury. And by doing so, it simply means that you will not be having a trial by jury. However, your case will still come before the court in one of 3 ways. One way that your case will come before the court is by way of a bench trial. That means that's a trial by a judge only. You won't have a jury, and the judge will listen to the evidence, and then the judge will decide whether or not you are guilty or innocent after listening to all of the evidence. Now, you also have a right to enter a plea agreement. There are 2 types of plea agreement. Now, you have a right to enter what we call an agreed plea bargain. What that is, a plea agreement is you and the state will come to an agreement to settle your case. For example, let's say that you've been in jail 5 days, and let's say the state is offering you 5 days in jail. And so you agree to accept that. Then that's a plea bargain agreement. Now, that case still have to come before the judge for the judge to decide whether or not the judge will follow or not follow the plea bargain agreement that you have entered into with the state. If the judge does not follow the plea bargain agreement that you have entered into with the state, you can simply withdraw, or you can take your plea back, okay, and not go along with it if the judge does not follow your plea bargain agreement. If the judge does follow the plea bargain agreement, and if you want to appeal your case within 30 days, then you have to get permission from the judge to appeal your case. Now, the other way that your case will come before the judge is by way of an unagreed plea bargain. And what an unagreed plea bargain means is that you and the state have not been able to reach an agreement, but you want the judge to decide what your punishment will be. We call that an unagreed plea bargain agreement. Now, you also have a right to have a trial by, well, you also have a right to have witnesses to come to court. And that chair over there where that microphone is, we call that the witness stand. And what witnesses do, they can testify. Now, they can either testify for you or against you. we call it either direct examination or cross-examination. Now, if you're represented by an attorney, the attorney could ask them questions, or if you're representing yourself, you can ask them questions. Now, you also have a right to waive or give up your right to have witnesses, meaning that you have a right not to call any witnesses in your case. And by doing so, you would not be calling witnesses in your case. However, that does not mean that the state will not be calling witnesses in the case, because they're bringing the case, they will be calling witnesses in the case. You also have a right against the Fifth Amendment right against self-incrimination. What that simply means is that you have a right not to testify against yourself in your trial. Now, you can waive your right, in essence, give up your right, your Fifth Amendment right against self-incrimination, and decide to testify if you desire to do so. Now, you also have a right to have discovery. Discovery is you have a right to see the evidence that the state has against you. Now, if you want to see the evidence, you can see the evidence. You can have access to that evidence. Now, if you do not want to see the evidence, you can waive or give up your right to have discovery in your case. Now, everyone here that's here for arraignment, you're here because you have, one, you've been arrested, and two, you bonded out. Now, you're out here, you're out of jail in one of three ways. One, you're out on what is called a cash bond, meaning that you put up the full amount for your bond to get out, or you have what is called a surety bond, which means that you have a bondsman who is on your case, and that's how you got out of jail, or you got out on your personal recognizance. We call that a PRA bond. Now, every day that you spent in jail, that jail time can be used as credit towards your punishment. So, for example, let's say the state is offering you, let's say you spent 5 days in jail, and let's say the state is offering you 5 days in jail. That simply means that you would not have to serve any more time in jail, because the time that you spent in jail, you'll be given credit for time served. You've already served it, so you won't have to serve any more time in jail. Now, every day that you spent in jail counts as $100 that can go toward your fine and court costs. So, for example, if the state is offering you a fine and court costs of $500, and you've already spent 5 days in jail, that's $500. That means that you will not have to pay the $500, because it'll be taxed and retired, because the time that you spent in jail has already paid it off. Now, if they offer you a fine and court cost of $700 and you spend 5 days in jail, that means you have to pay $200. Now, if you can't pay that $200 on the day that your case is disposed of, then we could put you on what is called a payment plan. You could pay it off in installments. Now, let's say, even if we put you on a payment plan, you might not be able to pay it off. Then, because of your income, then what we can do is, pursuant to Article 42.15 of the Texas Code of Criminal Procedure, the court can convert your fine and court costs to community service. That simply means you can work it off. And every hour of community service that you do, it counts as $12.50 that will go toward your fine and court costs. So if you work an 8-hour day in community service, that's $100 that will go toward your fine and court costs. Now, Jefferson County has a program that is called, the Jefferson County DA's office has a program that is called a pretrial diversion. It's for first-time offenders. And if you get into the program, they will dismiss your case, and you can get it expunged from your record. Expunged means wiped off, deleted, or erased from your criminal record. Now, in order to get into the program, one, it has to be your first time, it has to be your first offense, and two, it cannot be an offense involving unlawful carrying a weapon or resisting arrest. And then you have to have an attorney to assist you to get into the program. And as I said earlier, if you get into the program, case is dismissed, you complete the program, you could get it erased, deleted, or wiped off from your criminal history. Next, Jefferson County District Attorney's Office also has another program that is called Veterans Court. It's for anybody who's a veteran. If you are veterans of any one of the branches of the United States military, with that program is it's the same thing as pretrial diversion. You get into the program, your case is dismissed, you complete the program, you can get it erased, deleted, or wiped off from your record. It could be expunged from your record. And the only criteria to get into that program is being a veteran of the United States military. Now, this court, County Court at Law number 2, has a program that is called Community Safety Initiatives. We call it the CSI program. And the CSI program is a program that I started in March of 2017, within 100 days after being elected to the bench or taking the bench. That program, the CSI program, is a program that is designed to address the issue of what we call recidivism. Recidivism is where people commit crimes over and over. And so the way we address that is we have partnerships with various agencies in our community. One of the partnerships that we have is a partnership with the Spindletop Center, and then young people that's in the jury box from the Spindletop Center. With the Spindletop Center, what they'll do is they'll have private interviews. They'll do an assessment. They develop a treatment plan, either outpatient or inpatient, to address your mental health needs. Now, you do not have to be insane or incompetent to be in the program. If you have a problem, issues with depression, anxiety, bipolar, schizophrenia, PTSD, any host of mental issues, they can address those issues. The other thing is, if you have issues with drugs or alcohol, then they have a program that is called ATAR, which stands for Addiction Treatment and Recovery. Also, the Alcohol and Drug Abuse Council has a program that is called OZAR, which stands for Outreach, Screening, Assessment, and Referral. And those programs are basically similar in that they'll give you a private screening, they'll do an assessment, and then you'll be referred for treatment, either outpatient or inpatient treatment. Also, if you are unemployed or you're looking for a better job, we have a partnership with the Golden Triangle Empowerment Center. The Golden Triangle Empowerment Center has a partnership with Lamar University, and Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. And once you are trained in one of those areas, they will assist you at getting a job in the area that you are trained in. If you have not graduated from high school and you would like to get your GED, well, the folks at Lamar University, the CICE program has a GED program. And you can get your GED, your graduate equivalency diploma, by attending that program. Now, all of these programs that I just mentioned to you are free. Does not cost you anything to get into the program. All of these programs, they're free. They don't cost the county anything either. And so in order to get into the program, you just have to have a desire or interest to get into the program. The other thing is with these programs, as I stated earlier, was started here by me in County Court at Law number 2 in March of 2017. And I tell people this all the time: when you come to County Court at Law number 2, we do not have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court, and we're trying to make a difference in the community in which we live in, which is Jefferson County, Texas. Also, this program that we have in County Court at Law number 2, I like to look at it like this here. We do not just give time, but we take our time. And it's not because, as I said, we're different, but because we're trying to make a difference. We don't just arrest the problem, we address the problem. And we are trying to produce productive people. And we believe that if we produce productive people, we can make Jefferson County and our community a lot safer, because productive people have too much to lose. And so therefore, they would not want to commit crimes. And so therefore, we make Jefferson County a safer place for all of us to live, work, go to school, raise our children, and to go to church. Now, the paperwork that you have in your hand, we have some people in our court that can assist you. If you need assistance in filling it out, just let us know. At this time, we have someone from the Spindletop Center. We have Sarah, who is going to come and tell you what they have to offer with the Spindletop Center. So at this time, I present to you, Sarah.
Thank you.
You're welcome.
Good morning. I'm not Sarah. I work with Spindletop, usually accompanied by a mental health officer. The demographic page that I gave you earlier is some information just from me. It is HIPAA regulated, meaning that nobody will see this information except for myself, and it's a computer database. I will provide you when we're at recess with a template that contains more information about what we do. Will contain a 100 number that will have, that is a crisis hotline number, that if you ever find yourself in any place, you can utilize that number. As we go into recess, you are welcome to talk with me, whether it be more information about our services, there is going through something, that is going to be completely up to you. Does anyone have any questions or questions?
Okay, thanks a lot, Sarah. So again, ladies and gentlemen, I mentioned earlier that if you need some assistance with the paperwork, we have people in our court who will be able to, on our court staff, that will be able to assist you with filling out the paperwork. Now, one thing that we're going to do is once we pick the paperwork, we have to go through it, and then we're going to call you up to the bench one at a time. And when we call you up, you're going to stand in front of the X in front of the bench. So at this time, this court is going to be in recess to give us time to allow you to finish filling out the paperwork, and so that we can pick it up and then call you up one at a time. Okay? So at this time, the court will be in recess.